Our next speaker is Professor Jim Rossi. He comes to us from the Florida State University, and he'll be discussing state executive lawmaking in crisis. So please welcome him.
Thank you. Thank you. I am waiting for the screen to appear magically, which I'm told will happen at some point once I begin speaking. But just to actually... Here we go. In any event, just to get things started here, this project tries to take the event of recent crises as a springboard for thinking downward, looking downward or peering downward to state and local government and thinking about some of the constitutional issues that state and local governments face in reaction to crisis. And the project is in part, it draws in part from some of the descriptive and explanatory work I've done on state separation of powers, and then it tries to make some more general normative proposals. So, it starts with, I guess, the explanatory and the descriptive, but then it becomes deeply normative. And I guess, as an initial disclaimer, I should add that we should take some of this enterprise with a dose of modesty. And is the screen going to appear here at any point? Yeah. Gosh, I had this great introduction. I was going to begin with a cartoon, but but oh well, I'm beginning without the cartoon. So I want to take things with a dose of modesty in suggesting that there are going to be limits on what law can accomplish here, given that so much of what likely happens in reaction to a crisis is political. With that in mind, I think law can play an important role in setting up the right incentives, designing the right institutional rules, and channeling energies in the right direction. So let me begin by just tracing out the structure of the argument I make in the paper. I begin with a couple of well-accepted observations, some of which have already been put on the table this morning by the other speakers. First, a state crisis management and state and local crisis management takes place within a federal system. But state and local governments have some positive role to play in crisis management. If we look at the structure of federal laws, we see that routinely is the case. The Stafford Act, for example, gives state and local governments primary responsibility in reacting to emergencies and to crises. Secondly, the paper begins from the observation that problems in defining authority can and often do thwart efficient and prompt resolution of crisis. In many ways, this is a variant on Ben DePorter's thesis, which I think he nicely illustrated in the context of an economic model earlier this morning. I then move on to some under-recognized observations, in part under-recognized because state and local government is under-examined in the context of crisis management. It's my claim in the paper that actual and perceived limits to state executive authority within state systems of government can contribute to the confusion regarding who has the authority and or responsibility to act in response to crisis. And I'm focused really on two particular kinds of legal problems that evolve in the context of state government. First, there's a problem of obsolescence in state statutes that I believe can sharply limit the actual or perceived authority of state executives to act, particularly given state separation of powers doctrine, which I'll come back and talk about in just a little bit. Second, there's the issue of ambiguity under federal statutes and legal ambiguity that occurs given federal-state shared jurisdiction, which can leave it unclear whether states have any jurisdiction at all to act, or which might discourage state officials from acting, given an expectation that federal officials might step in and solve various kinds of problems. I then conclude in the paper that the case for inherent state executive authority to engage in lawmaking in response to crisis is stronger than any kind of case that can be made for emergency executive powers at the national level. I propose in the paper a normative proposal, an interpretive presumption for state constitutions, which would basically be a presumption that state executives have the authority to engage in lawmaking during times of interstate crisis or in response to natural disasters, attacks, economic crisis, although this presumption, given that its shared authority with the legislature, can be overridden by legislative action. So at the outset, I think it's important to recognize that crisis is not just any old policy decision. That crisis has certain indicia that separates it from other kinds of policy decisions. So crisis, is basically a surprise. It's the kind of thing that's very unpleasant, extraordinarily unpleasant, and it requires some sort of immediate response. So a lot of policy decisions, a lot of really big policy decisions are not the kinds of crises that I'm talking about. But there are many different kinds of crises, and the kinds of crises should not be understood narrowly in response to the most recent crisis, but ought to be understood broadly to encompass the range of crises that different executive and other officials in government face. So we have examples of attacks such as the World Trade Center bombings, natural disasters such as Hurricane Katrina, interstate crises, a sort of problem I'm focused on a lot in this paper, California's electric power crisis, immigration problems, economic crises. State legislatures, for example, might fail to pass a budget. And as Texas has recently reminded us, political crises can sometimes evolve. Redistricting in Texas led the governor of Texas to declare an emergency. Now, implicit to my paper is the notion that there are some advantages to the emergency state executive. I think earlier this morning, Stuart Benjamin made the observation that there's something to be said for a unitary executive at the federal level, that many of Ben's suggestions regarding concurrent authority, overlapping authority, might bode in favor of identifying someone as ultimately being responsible for kinds of problems. And a unitary executive at the federal level is one type of solution. But I want to suggest in this paper that there are certain advantages to the emergency state executive. Just to trace a few of them, state government, of course, is closest to the problem, while Congress or federal authorities are more likely to be swayed by short-term credit problems that don't necessarily have anything to do with the specific jurisdiction in which the issue, the crisis, might evolve. There's broader accountability to be gained by state executives than by looking to, say, local officials or state legislators, because the state executive is elected on a statewide basis. The state executive typically has the entire machinery of state government at his or her disposal. The state executive will have the ability to act quickly, particularly vis-a-vis the state legislature. And the state executive frequently has flexibility in terms of the ability to respond and adapt to solving problems. There are also coordination advantages to a state executive. There's an ability to identify one person who's able to negotiate with extra state authorities, whether these authorities are the federal government or other states. But as I suggest in the paper, there are two kinds of ambiguity regarding the legal structure within state executives' work that can confuse decision-making. There's vertical ambiguity and horizontal ambiguity. And by vertical ambiguity, I mean federal-state ambiguity, ambiguity regarding who has the authority to act within our federalist system. By horizontal ambiguity, this paper focuses on horizontal ambiguity within states, in contrast to the kind of horizontal ambiguity that Ben DePorter was talking about this morning, horizontal jurisdiction across states, which is largely outside of the scope of this paper. So I'm really talking about the horizontal ambiguity that occurs within a state system of government where a legislature, a governor, another statewide elected official might have authority to act. Now, to begin with the problems under federal law, state and local governments are typically given the primary responsibility for crisis management and response. This is the structure, for example, of the Stafford Act. And ambiguity under federal statutes can leave it unclear at times whether states have any jurisdiction to act. Even to the extent it might be clear that states do have the jurisdiction to act, at times the concurrent jurisdiction of federal and state law here might create incentive problems, as Ben pointed out this morning. There are many examples. Hurricane Katrina, the problem that initially got me thinking about this issue is California's electric power crisis, in which California's governor wanted FERC, the Federal Energy Regulatory Commission, to step in and do certain things to respond to the energy crisis in their newly deregulated system for distributing and selling electric power. In the paper, I lean in the direction of embracing a presumption of state authority to act. I think it would be a good thing to have some sort of notion that state officials generally have a presumption that they can act, that this would enhance accountability at the state level as well as at the national level, and it would simultaneously encourage federal authorities to intervene earlier if they anticipate taking action. The arguments for this are somewhat similar to the arguments for the presumption against preemption in federal constitutional law, although here, since this is an area in which Congress can clearly preempt the states, I'm not arguing that this has constitutional status, but rather is a matter of federal law, but rather that this presumption has important implications for the operation of state constitutional law. The paper then goes on to focus on what I see is the real problem here. And the real problem here might lie within the structure of state constitutions. And particularly, I focus on the claim that actual and perceived limits to state executive authority under state constitutional law can contribute to the accountability breakdown of the sort that Ben described this morning. And in particular, I'm focused on state separation of powers doctrine. And state separation of powers doctrine is a very unique and in many ways underexplored and certainly under-theorized animal here in comparison to federal separation of powers jurisprudence. And if you look at state constitutions, on the one hand, state constitutions frequently speak to the emergency powers of governors and other officials within the states, which would suggest that there's some sort of constitutional, inherent constitutional authority for these officials to address the problems that arise in the context of emergencies. On the other hand, states endorse more generally a strong notion of separation of powers, a stronger notion than I think we have in the federal system as a general matter, although there's some variation from state to state. This would suggest that the only emergency lawmaking powers possessed by the executive at the state level are delegated powers, powers that have been assigned by the legislature. So the paper focuses really on the distinct arguments that on the one hand, the emergency powers of governors might be understood as inherent powers under state constitutions, or on the other, they might be understood to be delegated emergency powers, which are derived from the state legislature. And how one answers that question, I think, can have important implications for how governors will face incentives to act in the context of response to emergencies and crises. So state constitutions, as I've mentioned, have this rigid separation of powers notion, which lend credence to the view that emergency powers are delegated only. Strong non-delegation doctrine predominates in the states, which generally would preclude executive officials from making broad declarations of law independent of specifically assigned pockets of authority from the state legislature. Also, it's interesting to note that unlike the unitary executive that we have at the federal level, at least 48 states have a fragmented executive in which at least one other state official, apart from the governor, is elected in a statewide election. This can be an attorney general, it can be a secretary of state. In some instances, it's a secretary of education or other state officials. In addition, I think it's important to recognize a different feature of state government that deserves recognition is state legislatures meet part-time and meet infrequently. So at a minimum, we can expect a state legislature to be slow to the draw in responding to any sort of crisis issue. Indeed, I think there are manifestations of the notion that most state courts understand authority in the state executive to be delegated from the legislature, not inherent, even if we're talking about emergency authority. Overwhelmingly, I've looked at a lot of the state cases, and the state judicial cases take the position that state executive authority during times of emergency must be specifically delegated. And there are many instances in which state Supreme Courts have said, look, the state legislature ex ante didn't define this ability to act on the part of the legislature, so the executive branch is acting outside of the scope of its authority when it does something like, for example, declare an emergency for purposes of addressing an issue such as prison overcrowding. Now, most states have fairly detailed statutes which actually go so far as to define emergency, to lay out the powers of the governor or other executive officials, and to provide a process for legislative involvement, often ex post after the emergency has been declared. The problems I see with these statutes, as I describe in the paper, is that frequently they do things like define emergency narrowly. There are some examples where states have defined emergency to mean only natural disasters, but not to include things such as electric power crisis, any man-made disaster, attacks, and the like. Another problem I see is that sometimes no lawmaking power is provided at all for the state executive, or to the extent the state legislature has addressed the issue of lawmaking power, it limits it. For example, some states will say the executive can issue an executive order that has the force and effect of law, but that's only valid for 30 days or something to that effect. A third problem is that frequently the executive doesn't have any spending power, or if the spending power is addressed at all in these kinds of ex ante statutes, they will say things like the state governor can't spend more than $1 million in response to one crisis, or $3 million is in one of the state statutes. That's not a lot of money in response to a major state crisis of the sort of, say, Katrina. So in part, one way to understand the issue that's presented here is that we have state legislatures ex ante trying to define when executives can act during the course of emergencies, and yet a state legislature can't anticipate every kind of emergency that's likely to evolve. One way of understanding this kind of problem, of course, is as a problem in statutory silence, perhaps a problem in the obsolescence of a state statute. And as I suggest in the paper, in reaction to the problem presented by stale or overly narrow statutes, there might be some grounds for allowing the executive greater lawmaking authority or a lawmaking role during times of emergency when the legislature's not meeting and addressing these issues on its own. Indeed, at the federal level, as we're all familiar with, the issue has been addressed by the U.S. Supreme Court, and the classic pronouncement on this case comes from Youngstown Sheet and Tube versus Sawyer, the case in which Supreme Court declared unconstitutional President Truman's seizure of the steel mills in response to a labor crisis. And Justice Jackson, in his concurrence, suggested when the president acts in absence of either congressional grant or denial of authority, he can only rely upon his own independent powers. But there is a zone of twilight in which he and Congress may have concurrent authority, in which its distribution is uncertain. Therefore, congressional inertia, indifference, quiescence may sometimes, at least as a practical matter, enable, if not invite, measures on independent presidential responsibility. In this area, any actual test of power is likely to depend on the imperatives of events and contemporary imponderables, rather than on abstract theories of law. So, in similar spirit, I'm suggesting that there is this concurrent zone of twilight that exists at the state level, as well as, at least according to Justice Jackson, at the federal level. And in the paper, I endorse and argue for a state constitutional presumption during times of emergency. And this is a presumption that the executive branch has the authority to engage in lawmaking during times of interstate crisis, in response to natural disasters, attacks, or economic crisis, which, of course, can be overridden by legislative action if the legislature chooses to act. The issue that arises, of course, is to what extent, if at all, is this consistent with state separation of powers? And I argue in the paper that to the extent state separation of powers exists is a doctrine to actually protect against faction in lawmaking and to increase the accountability of lawmaking at the state level. This is consistent with the overall goal of state separation of powers. Typically, during times of crisis, and in particular interstate crisis, parochial interests will be less likely to predominate if we're talking about the actions of the state executives. Just to take one example, in response to Hurricane Katrina, many states dealt with the issue of whether they should suspend state rules prohibiting unauthorized practice of medicine by out-of-state physicians. These rules, of course, might exist for purposes of protecting consumers, but they also have the effect of impeding new entrants into the practice of medicine in these states. So suspending the rules doesn't necessarily promote faction in lawmaking. It might even promote accountability in lawmaking more generally within that state system of government. Particularly as you move to interstate crises where the impacts of the events transcend the geographic borders between the states and begin to implicate national policy on which Congress sometimes, but not always, has spoken. If we vest authority to act with state executives, this might even be understood to be a legitimate extension of federal preemption doctrine, right? It can solve both the preemption ambiguity and the state separation of powers problems with the same legal basis, that is, deriving this authority from implied preemption of Congress. There are some operational issues that evolve, as I discuss in the paper. I suggest that the presumption might vary in strength depending on the kind of crisis. I think the interstate crises that I've been talking about, where Congress has in some way spoken to what would be good national policy, might be the strongest ground on which we can presume executive authority to engage in lawmaking that's consistent with congressional objectives. I suggest in the paper that this would include lawmaking is an inherent executive power. And by lawmaking here, I mean basically the ability of the state executive to make statements that have the force and effect of law, that are binding on those who are subject to them. I argue in the paper this also includes an appropriation power on the part of the governor. This is perhaps a controversial claim within state constitutions as it is within the context of federal constitutional law, but I guess I should remind the audience of a wonderful paper by Greg Sidak in Duke Law Journal, coincidentally, published in the late 1980s on the president's power of the purse, in which he argues that not every appropriations power with respect to the executive has to be approved ex ante by the U.S. Congress. It seems to me this line of analysis could also be explored within the context of state constitutions, and that there might be some interesting insights to be had here with respect to the ability of the executive to spend money during times of emergency that hasn't been appropriated. Other operational issues that arise is that I understand these powers to be inherent but not exclusive. They aren't exclusive executive powers. They're shared with the legislature. The legislature can override them. In other words, I'm putting them in this zone of twilight. Generally, what would suffice for override? I don't embrace a supermajority rule, really. Absent some sort of veto, I suggest a majority will suffice, absent a veto. Interestingly, Congress and the federal government can always step in and override here, and this is a very important point that I'll come back to in just a moment. And I also suggest in the paper here, although I'm still thinking through the implications of this, that this, in the context of crisis, in the context of surprises that demand some sort of immediate reaction and that have extraordinarily unpleasant effects, this ought to be non-reviewable in the context of state courts as to the use of the emergency power, although courts obviously have to have the power to acknowledge the existence of the executive presumption. Otherwise, it's kind of a self-declared presumption on the part of the executive branch. There are some practical implications here, and particularly I'm suggesting that state emergency management statutes sometimes go too far, and that invites judicial and legislative meddling of a sort that's not really useful here. If you agree with my analysis, these statutes will still have some role. I think it's useful for a governor to know ex ante what a legislature thinks. But the primary role of these statutes would focus on the legislative procedure for limiting the executive ex post, rather than on ex ante constraints on the executive declaration of emergency, executive lawmaking, and spending during times of emergency. So I think legislatures would better spend their time focusing on what to do once the emergency happens. Perhaps things like joint resolution, declaration of emergency by the legislature, apparatus like these might be quite helpful in this context. There are also some conceptual implications here, and one of the broader claims I make in the paper, which might warrant some further examination in the context of executive decision-making at the state level, is that state executive power, at least in the context of emergency, a stronger claim can be made for this than can be made for the power of the federal executive to react during times of emergency. And the argument here proceeds along the following lines. As I pointed out before, there are simply more checks on the exercise of state executive power than there are on the exercise of executive power by the U.S. president. Congress, of course, can always step in and override an emergency decision of the state executive under federal preemption doctrine, under the supremacy clause. Not only Congress, but many federal agencies might possess the same authority. Federal courts, of course, can also declare state action unconstitutional where federal rights have been violated. And the broader implications for state constitutionalism are to try to position state constitutions within the debate about federalism. The paper sees separation of powers in functional terms rather than in formalistic terms at the state level. And finally, it doesn't embrace, as most of the state constitutional law literature does, any sort of notion that judicial interpretation is the starting place for state constitutionalism. Instead, I suggest there's a co-equal role for legislatures and executives. So to conclude, what's at stake here is really the issue Ben was discussing earlier, the accountability of lawmaking in a context where we recognize that shared authority is the reality under which we're going forward. And also what's at stake here is the virtue that the state executive can bring to bear on solving these kinds of problems. I think my proposal can create some incentives for quicker response action by Congress and by state legislatures. But at the same time, I don't want to overstate the case here. The presumption of state executive authority is not a panacea, but I think it allows states to play a more important role in crisis management. And just to get to my cartoon here, I apologize, somehow it kicked me out of the slideshow here. But in any event, I don't know if you can read this, but we have here, this illustrates that the problem of crisis management really transcends cultures, different eras, different times, and also cuts across many levels of authority, right? So we have two tribal leaders at a pedestal of a statue of one of their gods and a couple of volcanoes brewing in the background. And one leader turns to the other and says, he's good with crops, but slow to respond to an emergency. Perhaps not even law can solve these kinds of problems, but law might make some difference at the margins with respect to the incentives we can put into place. So, in any event. Do you want me to take questions? Or Curtis? Yeah. Sorry. Yeah, Matt, did you have a question? Matt? No. Let's start with Doug. Yeah.
Really interesting to think about there. I was particularly struck by the comparison of the presumption of state authority to presumption against preemption. And I was taken by your qualifier that the feds ought to be able to sort of intervene or displace the presumption at least where they contemplate taking action. And that struck me because one of the arguments we're seeing increasingly in the context of federal agency preemption is the idea that even though we're displacing a state environmental law or consumer law or tort law, we, the feds, are putting little in its place, we still think on net that we're actually benefiting the environment, benefiting consumers, workers, et cetera, because there's a variety of ways in which we think a deregulated space is actually better off than the state regulatory alternative. So the voluntary private sector can do a better job here than the government. Government regulation leads to unintended consequences. Consumers are irrational and will misperceive the important warnings. Maybe even temporary problems with deregulated electricity markets. In the long run, we'll all be better off if we just have the patience to wait through the transition. So I guess the question I have is, are any of those arguments compelling to you as we move into the crisis, disaster context, or do you remain wedded to the qualifier that at least you'd like to see the feds taking some affirmative regulatory action instead?
Well, yeah, the answer to both, to both questions, I think, is yes. But the implication of this kind of analysis for state constitutional law might be to suggest that the role the federal government is going to have to play in the context of coordinated federalism kinds of problems will be the federal government stepping in and stating goals, right? Stating goals that then could serve some sort of preemptive effect in the context of these kinds of interstate crises that evolve. So on a forward-looking basis, if we make these incentives clear at the state level, and if Congress wants to step in and preempt in ways that can authorize state executives to act on the behalf of the national government, Congress would be better off focusing on stating goals, stating clear goals to be pursued in the context of crisis management, rather than in detailing how exactly that regulatory system is going to work at the national level or at the state level. Does that answer the question? Yeah. Yes, Stuart?
So in the spirit, since for a while I thought I might be doing the commentary until I thought I had this. I had this.
You can do it right now. Yeah.
No. I have a few different sort of scattershot responses. Let me see if I can get them out. So one is a question about the obvious play in the joints is what is a crisis, and so how is it going to be defined? And we've got a situation where you've said that courts actually aren't going to be playing much of a role other than to say to the state executive, go ahead. Well, you and I both know from the world of administrative law, one of the big questions for agencies is when the agency claims in the first place something that is jurisdictional for the agency. So the state executive, I can imagine very easily wanting to claim lots of things are crises. Once you've got the power, once you've added in the California power situation, it seems to me that that quote from Youngstown was actually quite revealing about the imponderables. Mm-hmm. Not clear what a crisis is going to be, and not clear how it's ever going to be decided, even if we had courts involved. the executive's going to say, it's a crisis. I've got to move now. I can't wait for the courts. Or, I've got to move quickly. So that's one question. And then a second question that I have is sort of about kind of our role as academics. When we make proposals as academics for the Congress, part of the response is, who are you to do it? And our response is, well, we're citizens of the United States. It feels different to me when we're now giving advice and telling what 50 different states can do, right? To which their responses are going to be, well, what do you mean we, right? What input do you have for us? And it seems to me it cashes out in two particular ways. One, a state saying, gee, there's a lot of hubris in some outsider telling us that our statutes that we've created ex ante aren't good enough. And also some states saying, well, we think we're not similarly situated with some of these other states. We're not Louisiana, actually. We'll do a better job. First things first, we don't think we're going to have many crises because we think we're not in tornado country or volcano, and we're nowhere near any oceans. And we think we've sort of got a better handle. We've got a better infrastructure for it. So what you're proposing is sort of a one-size-fits-all. That's not our size. Yeah. And our ex-ante approach is good. Let me just throw my third thing. So then on the purely normative level, when you're talking about state responsibility for interstate crises, haven't we really raised a serious problem now? Because we're going to have different states competing then to have some control, or different governors competing to have control over interstate crisis, and we're going to be losing the advantage of the centralization that you were talking about by having just the executive do it in the first place. Those are the comments I would have given if I had been sitting there.
Sure. Well, let me start with your second point, because I think the point goes to the fundamental enterprise of this kind of scholarship. That is the kind of scholarship that might take as a springboard state constitutions or local government and try to generalize. And you're right. I mean, look, there's no way I can pitch this as a comprehensive proposal that will necessarily fit all 50 states, but I can look to features across various states, admitting that I'm not familiar with absolutely everything that goes on in state government, and make some effort to try to generalize to the extent there's any hope for a type of transnational, if you will, or trans-state constitutionalism that would have to happen. At a minimum, I don't expect that I'm going to be convincing state courts to just adopt wholesale what I'm proposing here. But the hope is that this will spark some sort of dialogue, and insofar as state legislatures do want to focus on state emergency statutes, that the focus will be on the ex post rather than the ex ante. So, like a lot of normative scholarship, it has somewhat modest, even though it has high aspirations at the outset. I think you're right. It's going to have very modest direct practical implications, but hopefully it can spark that dialogue and at least put some sort of burden in the political process with those who do want to meddle ex ante in trying to manage the executive, if you agree with the other arguments that the executive can be resilient, can be a good thing, can be introduce flexibility and accountability into the lawmaking process in response to emergencies. The other points you raise are really good ones. On what is an emergency issue, of course, there's a terrific quote in Youngstown by Justice Jackson, who argued that emergency powers would tend to kindle emergencies, right? That isn't anything an emergency. Social Security is an emergency. Global warming is an emergency. What isn't an emergency, for God's sakes? And I think we do have to, if operationally this kind of presumption were endorsed by any state court, I really don't think it's likely. But if it were, I think one of the steps would have to be defining a common law for delimiting what is a crisis. And this is something we do in our academic discourse. I mean, today I think we're focused on crises. We're not focused on all kinds of policies made by government. And there's something unique about crises, as I've suggested. They tend to be surprises. They tend to be the kinds of things that are extraordinarily unpleasant, and they tend to be the kinds of things that demand immediate responses, if there's going to be any kind of response. I think that we could then try to develop some sort of, we could call it a jurisprudence, but at least some sort of understanding of what is a crisis and what isn't a crisis. And I would agree that some of the things state governors have asserted as crises probably aren't crises. Is immigration a crisis? Well, I don't know. I mean, that's the kind of debate I think maybe we ought to be having as we assess the powers of the executive at the state level. With respect to different states competing and the confusion that's introduced here, I agree, and to an extent, I think that problem could be solved by having the unitary executive be at the federal level, right? I mean, if we just have this federal super regulator that can solve all these problems, although as others have warned, that's a little deceptive because the way that is administered is typically through bureaucracy, and bureaucracy becomes a management and coordination problem of its own. The problem, I take it with that, is that that's perhaps the most idealistic of all. I'm at least taking as starting point the notion that we have shared authority or coordinated authority, which, when you look at most of the federal emergency response statutes, is the framework. The framework is typically understanding that states and local governments have the primary responsibility and primary authority to be the first reactors in response to emergencies. And perhaps from an efficiency perspective, that's not a bad thing. If we had the federal super authority, super regulator here, we might have overinvestments in the wrong kinds of precautions. State governments are closer to the problems and might be better equipped to adapt to the specific needs of their residents and their citizens who are exposed to different kinds of risks. So I don't know if it's necessarily the case that it would lead to better or more accountable or more efficient planning ex ante for disasters. Matt, did you have a?
Not very persuasive. So let's assume we agree with you, and that it would be a good thing to have, this norm of state constitutional law, namely that the executives are presumed to have broad crisis management powers, subject ex post override by state legislatures. The question arises, how do we effectuate that, right? I mean, one way is to amend all 50 state constitutions. That would take a long time. Another way is to sort of, in effect, amend the rule of recognition in all 50 states. That is simply, have all the relevant actors understand that even without this kind of explicit statement in the state constitution, the constitution should be read this way. That's even harder to effectuate. The question is, can Congress just do it directly? Right? Can Congress directly specify a norm for interpreting state constitutions? What would be the Prince and New York implications of that? Insofar as it's framed in negative as opposed to affirmative terms, would that get around Prince and New York? Has Congress ever tried to do something like that?
Yeah, I mean, Congress, with respect to separation of powers, Congress on occasion has preempted states, and presumably Congress can preempt states with respect to different separation of powers norms. It's an interesting thing to think about. And I hadn't really thought through the implications for Prince. As I've formulated this so far, Congress isn't requiring the state to do anything specific, right? The governor, the elected official of the state, is still making the initial decision. So there might be a way around the Prince problem in thinking through how this would play out operationally in any given case, right? So Congress in no case is requiring a state to do anything. It's just saying the governor's authorized to act with the legislature through hamstringing the executive ex ante is precluding the executive from acting. And given that the legislature is typically not available to meet within a quick enough time to really solve some of the problems of.
You're not requiring acts, that is crisis management acts by the executive. You are requiring, in effect, sort of an interpretive act. As you're saying, affirmatively, you got to read the state constitution this way as opposed to some other way. But it's a subtle. I mean, it's as you know.
No, that's right. That's right.
It's a subtle sort of.
Yeah, and it's a sort of preemption. I mean, Congress can and has, in some instances, preempted state legislatures by authorizing state governors to act in certain ways that the state legislature may not have previously authorized. So that might be an instance in which, by making an analogy to that, this would be a similar sort of exercise of power by Congress. You're right. You are authorizing. You are requiring a certain kind of action, supersession, preemption, if you will, of the state constitution. But you're not requiring the particular act in the sense of the political judgment by the legislature, the political judgment by the executive. That would still be left to the state political process.
I have a question regarding political feasibility. As you said, it's a very normative story. So I was wondering, at first I thought, well, political feasibility issue is there someone who wants it other than assuming us academic society is good? Are there political actors that are interested in a amendment in this direction? And first reaction was no. Why would they want to? And why would the executive? Why would they have more power, lead to more liabilities and more responsibilities? But then again, when you talk about issues like delegation of power, I think it's a neat illustration of how public perception is very different, and public perception of accountability for the states is does not, delegation of power, that kind of technical term, that does not come across. I think that no governor even makes the case of, well, my hands are tied, I have delegation rather than the full authority. So no, public perception is meted out much more broadly, and so they're held accountable anyway. So is there, so it makes sense for them to have more power to mitigate some of the damage they will get anyway, despite technical arguments. Do you have any indication of governors where they actually, where they indicated a demand for what you're proposing here?
Well, I'm familiar with some instances in state administrative law where governors have wanted to act, or where state agencies have wanted the authority to act, but the state legislature has refused to give it. And in the context of disaster management, I would say an example might be California's electric power crisis, where Governor Gray Davis was hamstrung by the state having made certain policy decisions, the state legislature having made certain policy decisions. And the governor didn't try to upset any of those major policy decisions that have been made by the state legislature in adopting the deregulation plan. The governor could have gone in much more drastic directions towards returning to a regulatory structure in reaction to the power crisis in California, and he didn't. He didn't until the state legislature stepped in and approved going in that direction. So had the governor had this authority, it might have given him more space in which to react to the emergency. Whether he wanted it is another question, because I think he was an active participant in the finger-pointing game that you pointed out a little earlier.
Thank you very much, Mr. Rossi.
Thank you.
I don't mean to cut it off prematurely. I see our visitors from the Senate have arrived. I know they have a somewhat tight schedule. So lunch is ready out just outside the door here. And we could just take a quick break, get lunch, and come on back in. Of getting settled back in. So, and